Sorry.
No, you're fine.
Sure, this should be short.
Sit down in the audience. You okay?
You're getting too much instructions, aren't you?
All right, how old is that person who just left? Okay, because people who are underage, unless school is out, they should be in school.
Oh, okay. I believe there was somebody reference. Everybody like you.
All right, everyone, I'm going to call the docket. When I call the docket, I need you to stand up and answer that you are here. If you do not, I'm going to assume you're not here and a warrant may be issued for your arrest. Mr. Meyer, you may want to go ahead and take your seat at the table. Christopher Acosta. Christopher Acosta. Jose Lozano. Jose Lozano.
It's all good, man.
Oh, you know what? I was like, nobody's here. What's going on?
He's running late.
History book up there.
Thursday people would have been here very early. But you know what? I'm disappointed in all of you because how long did it take you? I went through almost 3 names. Bashan. All right. In custody, we have Missiel Solis, Louis Thompson, Alejo Aguirre, Layla Tanton, Karen Marino, Karen Grace Marino. Jesus Lopez is being recalled. In custody, we have Deneric Campbell, Bobby Rivera. Thank you. Sarah Gutierrez. Loretta Holmes. Thank you. Kent Wells. Nathan Bates. Victoria Velez. Victoria Martinez Velez. Lirio Laborde. We'll find out with his last name, whether he's from Louisiana or not, how he pronounces it. Edgar Jimenez, custody. Israel Fuentes Gonzalez. Israel Fuentes Gonzalez. Diego Mascaro, custody. Chastity Natal. Missiel Solis, custody. Loretta Holmes. Tyson Smith. Tyson Smith. Dondre Scott. Michael Reams. April Pettis. April Ann Pettis. Brandon Edward Diaz. Thank you. Elisa Hernandez. Elisa Hernandez. She's not present and I didn't even pronounce the H. In custody, we have Jose Amador. Gilbert Perryman. Gilbert Christopher Perryman. Miguel Perez Norano. In custody is Jimmy Dotson. Dylan Bell. Jesse Enao. Eduardo Reyes. Louis Thompson, custody. Alejo Aguirre, custody. Priscilla Para. Priscilla Para. Jesus Rivera. How do you pronounce this first name? Is it Jerez? Deek? Mr. Deek. Cherish Draper Ward, custody. Aldolfo Kalunga custody, Angel Pacheco, Wilfredo Salinas, and then what is your name in the purple? You. David Vargas. All right, anyone who came in late or your name was not called, we'll start over here. All right, sir, what's your name? Moses what? Could you spell the last name? All right, do you know your case number, SID number? 1110
023.
023. All right, you can have a seat. Who else over here? All right, here. Karen, what? All right, do you have a case or SID number?
Ma'am, you're in the first row. She's on page 27, Judge.
All right,
First row, first row. In the front, Karen Moreno, first row. Yes, ma'am.
all right, sir. Do you have a case number or SID number? Okay, is everybody whispering?
Do you have your jail card?
Thank you, Deputy Laura. Oh, I'm sorry, what's it? Oh, you'll look it up. Oh, no. Okay. All right, and you, miss? Terry, what?
CUDA.
And your case number, SID number? Seven 55989. Do you know who your attorney is? All right. Have you had any contact with him? All right, just give us a moment. All right. Everyone, this is what's going to happen today. We're going to finish up this punishment hearing. That should not take long. You all can still confer, and you can ask the deputy to bring your clients out, but you're going to have to be patient today because we're doing many things. So it's Tuesday. Everyone, please be kind. Please be patient. We will get to your case. Okay? All right. So family violence is right here. Zach
Yes, Your
is
Honor.
with family violence. So if you need some files from him, he will have them available for you. As you can see, these two prosecutors are going to be involved in this hearing, but the other prosecutor will be down, and your criminal files are over here. And just ask the deputy if you want somebody brought out. Because we're going to be on the record, please do not talk behind the court reporter because it will make it difficult for her to hear. So if you want your clients on the end, just ask for it. And everybody, please remember to confer with the probation officer. She's just not here for decoration. If she was, people would be putting their umbrellas on her and using her as a coat rack. So she is here. Confer with her if you have somebody on probation. If there is going to be a sentencing and a PSI report was prepared, she will be the person who will have that. Anything else? All right. All right, could I see? I think I have the file on this case. All right, we're going to go back on the record in 2024, CR 0170, State of Texas versus John Stephen Meyer. Can I have the parties announced for the record? For the state?
Hank Wilkins and Daniel Escobar for the state.
Charlie Baird and Mark Stevens for John Meyer.
All right. So we were here on the search warrant and I discussed with both parties off the record. And my understanding from both parties is that this search is not related to the previous search that the court ruled on during the trial. Is that correct, State?
Yes, Your Honor.
Defense, is that correct?
It is, Judge.
All right. So with regards to this case, I will hear your arguments with regards to the search. I spoke to Mr. Baird and Mr. Wilkins and told him what the court's concerns were and the questions I wanted answered. So y'all may proceed. And everyone, please remember, and I know you will, that with regards to the affidavit, we are simply dealing with the parole evidence rule and the four corners of the document. And State, did you have a chance to review Mr. Stevens' memorandum that he had put together?
Yes, ma'am.
All right.
Mention standing. I'll put that and be done with it.
All right. And you may be seated and argue from seated position, Mr. Stevens. It truly makes it easier for the court reporter.
If I promise to talk loud, is it okay if I stand, Judge?
Oh, sure.
My voice doesn't work when I'm sitting. Judge, the court raised the issue of standing. I think the state's witness yesterday amply proved standing by saying he's lived in that house since 2013. So through their own witness, that establishes a reasonable expectation of privacy in the contents of the house. Additionally, Your Honor, I think we pretty thoroughly argued what I call point number one about the warrant, and that is the purely conclusory statement about premises under the control and charge of John Meyer. Mr. Baird, I know, pointed out to the court before I arrived today that the case we cite on page 2 of our motion, of our objections, was Casillas. That's Cassias. And Casillas says, couldn't be more on point, Your Honor. In footnote number 2, Judge Clinton notes that the assertion that the premises are in the possession and under control of appellant is not attributed to the informant. In fact, it is a purely conclusory statement, the source of which is not given nor the reliability vouched for.
All right. So let me stop you right there. State, that's defense's first point with regards to the search warrant. What is your answer?
Well, Your Honor,
Or your response, I should say?
I guess first thing is it's either four corners or it's not. So bringing in the testimony from the neighbor, I don't know if that's, I think we're supposed to stay within the four corners. So I think that's, the first thing. The other thing here is, Judge, is the case, Supreme Court case, US v. I'm going to butcher this pronunciation, but Budan, Deaudion. The warrant is defined by its scope, not its target. The scope here is the house. On the first page of the warrant, in the 5th paragraph, it begins talking about the confidential informant, Your Honor. So, and then the confidential informant gives information to the police that narcotics are possessed by Peter Reyes. And then in the second page, the first big paragraph there, a client has reason to believe and does believe the information provided by the informant is true and correct that Peter Reyes is in unlawful possession of the above described controlled substances, methamphetamine.
So State, are you saying, because I'm just trying to pare down everybody's argument, are you saying that it doesn't matter that it's a conclusion? Just one moment. Are you saying it doesn't matter that it's a conclusion that Mr. Meyer lives at that location? That doesn't matter.
Judge, I don't think it's just me saying that. I think that's the Supreme Court.
No. I'm asking, is that what you're saying? That's either yes or no.
Yes.
I know people want to bring to me the weight of the Supreme Court, although I believe sometimes the Supreme Court may or may not make decisions that I wouldn't agree with. I will follow whatever the Supreme Court says because that's the hierarchy. But me following what the Supreme Court says, it's, of course, it's easier if the case is the same, but it's not 100% the same. So your answer to the defense's argument that Mr. Myers is in control of the Majestic Grove house, you're saying that really doesn't matter.
Right. Yes.
Okay.
I mean, I think it would be an absurd conclusion. You know, I think we talked about this a little bit off the record, but if I'm living with somebody else, I'm selling drugs out of that location, I'm surveilled, leaving that location, selling drugs to a confidential informant, and then returning to that location. I don't think it would be a reasonable result for the court to say, like, well, we can't search the house that Hank's living in because you know, this other person has property interest in it. It seems like an absurd conclusion to me, Judge.
Okay. All right. Defense.
Your Honor, the reason we bring it up is because we are talking about the four corners of the affidavit, and it's in the four corners of the affidavit, same as it was in the Casillas case, which Mr. Wilkins cited himself yesterday. So it does matter. And our point is, it adds nothing to the probable cause in this affidavit. Because it, just as Judge Clinton says, it is a purely conclusory statement. The source or the reliability cannot be attributed to the informant. They don't even try to attribute it to that. So we think it does matter.
Okay. All right. And then counsel, your next argument.
Point two, Your Honor, is the second part of the affidavit, which purports to establish probable cause, and it is located in about, let's see, the sixth paragraph down in the indictment, Your Honor, and it begins, affiant did on or about 10/26/22. That paragraph is what we're concerned with. It is also inadequate, Your Honor. So note this, 10/26/2022 is 6 days before the execution of the search warrant. So that alone, I think, renders it suspiciously stale. What does any statement 6 days before the execution of the search warrant say about what contraband may be found 6 days later on November 1st when this warrant was executed? But it goes on, Your Honor, concerning narcotics being possessed at the above location by Theta Reyes, not by John Meyer. So when were the narcotics possessed? The affidavit alleges when the affiant received the information from the undisclosed confidential informant, but it doesn't say when the informant said he saw, but he never even says he saw them. But how do we know when the informant, I'll just say, acquired the information? Again, was it 6 days before it was passed on to the affiant, or 6 months before? Who knows? The point is, the four corners of the affidavit require that it be stated in the affidavit. So we don't have any idea when those narcotics that the informant informed about were there at 224 Majestic. It says narcotics, and that's important, Judge, because we talked about it yesterday. Narcotics can be legal or illegal. Oftentimes the affidavit will talk about unlawful material, and this affidavit does too. When it goes on to talk about methamphetamine, it says the methamphetamine is unlawful, but doesn't say the narcotics are unlawful. And so we all know that narcotics can be prescribed and can be legal. And if so, what probable cause would an undisclosed narcotic tell anyone about the presence of drugs on November 1st? We say nothing. But the quantity is also important. What if it was one pill, one legally prescribed pill? Again, no evidence of crime, providing no probable cause for the 6 day later search. What narcotics were they? In what quantity? some of the cases talk about, Judge Cochran is known to say this. What about the quantity of narcotics observed? Does it, if it's a large amount, maybe you could say a reasonable inference is a large amount of methamphetamine is found in the house, and 6 days later, it's probably still there. But how can you say that when you don't disclose anything at all about the quantity of, again, not methamphetamine, but narcotics? And the basis of the informant's information, basis of his knowledge, that's a well-known important fact. This affidavit, this paragraph I just cited, says nothing about did the informant see it? Did he have personal knowledge of it? And the court knows that that's the way these things, there ought to be a basis of the information. So the reliable and credible informant has seen narcotics within X number of hours. Not only do we not have the X number of hours, we don't have anything about the basis of the informant concluding that Theta Reyes was in possession of narcotics at this home. So for all those reasons, this second paragraph, and that's our second argument, Your Honor, the second paragraph does nothing to give a fair probability that methamphetamine, and that's the subject of this search warrant, that methamphetamine would be found 6 days later on November 1st. So the only thing they have left is, again, what I'm going to call the incomprehensible paragraph that's 4 paragraphs down, because the rest of it doesn't say anything about, it just talks about the officer's experience and things like that. It doesn't say anything about the particularity of the facts relied upon in this 4 corners of the affidavit. So it begins with the paragraph we're talking about. The informant stated that she did within the past 48 hours of today's date. So I'd ask the court to consider that whole paragraph though. So within the past 48 hours of today's date, and that would be, by the way, October 29th. So the date's important, Judge, again, because it's confusing. October 26th is the date of the first bit of information that the affiant says he received the information from the confidential informant in the previous paragraph. October 29th was the date that this warrant was taken to the magistrate and signed by the magistrate. November 1st was the date it was served and executed and the evidence seized. So what we know then about part number 3 or point number 3 is that if the methamphetamine was seen within 48 hours, that means it had to have been either on October 29th, October 28th, or October 27th, not on October 26th. So we know that it had to be a separate incident. So what does this tell us about probable cause to go inside that home on that day? Well, it says that he saw the methamphetamine, okay, unlawfully possessed by Theta Reyes. So it would seem like 2 things there. 48 hours, prosecutor yesterday talked about, we've seen affidavits in which we talk about 48 hours, okay? That's right. But you got to read further, because it says that Theta Reyes possessed it, but it doesn't say where she possessed the methamphetamine. So was she at some other location? That's important, and not at 224. It'd be very easy, and affidavits often say this. They often say the confidential informant, known to be credible and reliable, saw methamphetamine within the last 48 hours at the above described premises. Doesn't say that here. So where was she?
Well, let me ask you this, because in the affidavit, it states the informant stated he or she did within the past 48 hours of today's date see a controlled substance, to wit, methamphetamine, unlawfully possessed by Theta Reyes, who had came from the above described premises that was under surveillance by law enforcement to an undisclosed location where a controlled buy was conducted?
Exactly, Your Honor. Where was the methamphetamine when it was seen? Was it at 224 Majestic Grove? It doesn't say that. It says it was seen in her possession, and it says who had came, that's what it says, who had came from that location. And it seems to me the most logical conclusion is that the informant had something to do with the controlled buy. It doesn't say that, by the way. More vagueness, more imprecision, but that's where she was seen, arguably, and there's no other basis for where she was seen, at the undisclosed location of the controlled buy. So it says she had come from and she returned to it sometime. But when did she leave 224 Majestic Grove? It doesn't say that. So did she leave? And when does this controlled buy take place? Again, 48 hours, within the last 48 hours. So are we able to say from the four corners that Theda Reyes, not John Meyer, but Theda Reyes left 224 Majestic Grove, went to the location, the undisclosed location of the controlled buy? Why isn't that disclosed? Went to that location, wherever it was. Was it a block away? Was it 20 miles away? Did it take her 3 hours to get there? So, and that's important because the longer it took, she could have stopped off somewhere and got the drugs. She could have had the drugs with her in the vehicle. What then, from the four corners of the affidavit, ties this possession of Theda Reyes to 224 Majestic Grove? Not the time, because it doesn't say within the last 48 hours she was seen at 224 Majestic Grove in possession. It just says she left at that address within the last 48 hours. So what did she do in the next 48 hours? What did she do before the controlled buy? Doesn't say. So it could have easily said, we followed her. We had continuous surveillance from the time Theda Reyes left the location. It could have said she carried a box out to the car when she left the location. Doesn't say anything about that at all. So the fact that Theda Reyes was in possession was seen in possession of methamphetamine sometime within 48 hours at an undisclosed location says nothing about whether there's probability, a fair probability, that those drugs had anything to do with 224 Majestic Grove. And then it says she returned. So again, so what we know from the affidavit, even if we take every word of it is true, at some time within 48 hours, she left Majestic Grove, and thereafter at an undisclosed location, she was seen in possession of methamphetamine, and then she returned. No surveillance, no knowledge at all, no information at all about what happened between leaving Majestic Grove whenever she left and coming back there, other than that somewhere in between there was a controlled buy. So it says nothing to tie the drug, the methamphetamine, and more, Judge, doesn't say how much methamphetamine. And that matters because if you've got some basis for believing that from the affidavit that there was this drug lab or that there was a continuing drug operation at 224 Majestic Grove, that's something. It doesn't say anything at all about that in this affidavit. So again, Judge, there is no tie to whatever amount of methamphetamine was involved in the controlled buy at whatever location it was at whatever time, that and returning to Majestic Grove. So why, again, if we take the third paragraph in conjunction with the first paragraph we talked about or the second paragraph, there's no way for a person who was executing that search warrant on November 1st to believe, and there's no way for the magistrate who signed the warrant to believe, based on all of this, that there would be drugs at 224 Majestic Grove when they returned to search.
All right, State.
Your Honor, I think on the one hand, counsel is objecting to, there's too much information in this affidavit, and then on the other hand, he's saying there's not enough affidavit, so I'm not sure which it is, but Your Honor, the case law says 52 hours is okay. That's that Swearingen state, new state that we talked about yesterday. The case law says 72 hours is okay. That's that state unifying CCA case that we talked about yesterday. In this case, it's 48 hours later, less than what's required by the CCA. A reasonable inference from the facts in the affidavit is that the officers surveilled the location. They watched Ms. Reyes sell narcotics to the confidential informant and then return to the location, Your Honor. So we believe the affidavit is sufficient to support the finding of probable cause, Your Honor, and we don't believe the defense has met their burden.
All right, and
Could I just
defense,
point out,
oh, just one second, defense, I'm gonna give you the final argument because it is your motion. You may begin.
I've got a copy of the Swearingen case. I didn't get it from counsel, but I have it. It says that according to the affidavit, and by the way, this all happened on one day in Swearingen, January 10th, 2001. According to the affidavit, I'm quoting now, according to the affidavit, a confidential informant told Sergeant Howard that he had been inside the house within the previous 52 hours and had personally seen appellant in possession of a quantity of methamphetamine. Later that day, they executed the search warrant. So how many differences are between Swearingen and our present case? In that case, it all happened on the same day, not 6 days apart. But importantly, the confidential informant said he had been inside the house. So Mr. Wilkins says 52 hours is important. But the reason it's important is because he was in the house and saw the methamphetamine in the house that they searched. Nothing like that is contained in any part of this affidavit. What we have is an undisclosed location. Not enough, Your Honor.
All right, so with regards to defense's motion, that will be denied. And I'm gonna remind both parties that if this were being tried before a jury, then this would be an extraneous offense. So I will still have to make a finding in my mind whether I believe beyond a reasonable doubt that he was in possession of it. Is that if that's what the state is seeking to present, or he's in possession with intent to deliver. So the motion is denied, and I'm still looking towards, if the state is seeking to admit this, I'll still be looking towards whether or not he is in actual possession of it, and I'll be using the standard of proof beyond a reasonable doubt if that is what is going to be presented to me.
And Your Honor, he made the argument, kind of made the argument of standing. Does the court have any issue of standing based on Lorkovic's testimony?
I'm not basing my decision on whether or not your client has or does not have standing. All right.
Because I'm sorry, Judge. He says that the four corners, we're not limited to the four corners when we're talking about standing. That's separate.
No.
inquiry.
No.
I think I should cover what I was going to cover. Good job.
All right, and attorneys, please continue to confer. And whenever you all are ready, we'll take a brief break between this, and I can take up what the other attorneys are ready on. All right, State, do you have your witness? Yes. All right, if you'll have him come and take the stand. Yes. All right, everyone, just give me 2 minutes, please. And you have your witness take the seat.
Even we use this as a prosecution guide and the packet.
No, that's right.
Anita Hernandez?
So, just if you're thinking of something, just, refer to the. No, you don't have to hurry.
And everyone, when you're speaking with your clients, if you'll just please whisper. All right, state, call your witness.
State calls Jorge Rios, Your Honor.
All right, you were previously placed under oath, but I'm just going to do it again. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up so the court reporter can hear. I can hear, my allergies are acting up, and so that all parties can hear. State your name for the record.
Jorge Rios.
All right, state.
Good morning, Deputy Rios.
Morning.
Are you, who's your current employer?
Bear County Sheriff's Office,
And how long have you been with the BCSO?
18 years.
And did you have a specialized training to become a police officer?
Yes, several training hours and also narcotics training and stuff like that.
And are you a certified peace officer?
Yes,
And so you're familiar with this case, the judge is familiar with you because you testified in the case in chief, the guilt innocence phase, right?
yes,
And so as part of your duties, did you serve a search warrant, or were you part of the team that served a search warrant on 224 Majestic Road in August of 2022?
yes,
And did you, were you part of the team that arrested the defendant on that date?
yes,
And so a few months later, did you did you do further investigation on the same address?
yes, we did.
And why did you do that?
We were receiving information.
Objection to hearsay, Judge.
All right, that'll be sustained.
Did you receive complaints about the address?
Yes,
And so were those similar complaints that you got before you served the search warrant in August?
yes.
So what steps did you take before you served the November search warrant?
We conducted some surveillance at the address again. And we're also able to utilize an informant to conduct a control buy.
And who else was with you? Were other officers with you?
Yes, I can't remember off the top of my head, but I'm pretty sure Deputy Bettis and Deputy Salazar.
Was Deputy Wolf with you?
Yes,
And so you did surveillance on the 224 Majestic Road location?
yes.
And you mentioned a confidential informant.
Mhm.
Was that your confidential informant?
No, that was Deputy Bettis, confidential informant.
And in the warrant that you served in August, did you meet a person named David Alvarete?
Yes,
And was he a confidential informant?
no,
Okay, and did you have contact with him?
yes.
And what was the nature of your contact with Mr. Alvarete?
He was giving information. He was a roommate in the house, and he was giving us information, intel as to what was occurring in the house.
Did he want to be a confidential informant?
He did, but I could not utilize him at the time because he was pending family violence cases.
So if somebody's pending charges, they can't be a CI?
They cannot.
And so what were your contacts with Mr. Alvarete before the November search was executed?
Just text calls, talking about some of the activity in the house.
Sustain.
Did,
I'm sorry, Judge, I didn't hear the objection.
All right,
Objection to hearsay.
yes.
did you introduce Mr. Alvarete to the confidential informant in this case?
We did.
And did the confidential informant set up a controlled buy in this case?
Yes,
Were you part of the team that did surveillance for the controlled buy?
yes.
And can you describe, how does that work?
Basically, we set up a time and date. set up on the house itself and watch to see who leaves the location. And then we set up a location right around the corner to conduct the control buy so that we can have a short distance from the house to the buy. And we have undercover set up in the parking lot to observe the control buy, and another set at the house. Another one to set up to conduct rolling surveillance to follow.
And so rolling surveillance, can you describe that briefly to us?
Yeah, you're working covertly trying to keep eye on the vehicle that's rolling or moving.
And so in this case, who were y'all surveilling besides the house? Was there a person you were surveilling?
Yes, I believe it's Reyes is the last name.
And so did you have rolling surveillance on Ms. Reyes?
Yes.
So was there somebody, did you or somebody in your team have eyes on her the entire time once she left the house?
Yes.
And what date was that on?
I don't remember what date it was.
You have to look at those reports, that's okay.
Okay. Yeah, I don't remember what date it was.
So that was before you served the search warrant, right?
Yes, that was before.
So and did y'all get a warrant as part of this case?
Yes.
Were you the affiant in the warrant?
No, Deputy Pettis was.
So the warrant, do you remember the date the warrant was served, or is that in your report?
I believe it was November 1st.
And so typically, do you get the warrant the same day you serve the warrant? Do you do that before, a couple days before, the day before?
At least the day before, a couple days before, yeah.
And what's the purpose of that?
The information that's gathered and utilizing the control by as probable cause, you have a certain amount of time to get that presented to the magistrate.
Do you sometimes leave a gap in time to protect the identity of the confidential informant?
Yes.
And did you do that in this case?
Yes.
And were you part of the team that served the search warrant on the house?
Yes.
Did you search the house as part of your duties?
I did not.
What were your duties when the search warrant was served?
Just to take down names of the persons that were there, and also try to interview some of the people that were there that were willing to cooperate.
Okay, and so you're wearing your uniform today and you've got your body cam on. When you're working in your day-to-day capacity, do you wear the uniform?
No,
Are you wearing the body cam?
no.
And what's the purpose of that?
We work covertly, so we're trying to wear the least amount of identifying markings.
And are you in a marked police vehicle?
No,
So it's and when you're watching the controlled buy, are you undercover? You're in plainclothes?
plainclothes.
One moment, Your Honor, I'm sorry.
Okay.
I passed the witness, Your Honor.
All right, defense.
Detective Reyes, is it Rios or Reyes?
Rios.
Rios, I apologize.
Come on.
Detective Rios, let me talk to you about this. When did you begin surveillance on the residence?
It had to been at least a couple of days before. We did the control by, I'm not exactly sure on the date.
And was it a constant surveillance? Was it a rolling surveillance? What was the level of surveillance?
It was a few hours at a time. We had prior knowledge of the address.
And as it relates to this particular search, and specifically, you said the surveillance was a couple of days before. It was before the warrant was requested, correct?
Before the warrant was requested and before the control by.
Okay. The surveillance, did the surveillance show John Myers to be inside the house?
We did not see him.
Did not see him either coming or going from that location, correct?
Just one of the days that we were out there, we did see him drive. He had a rental that he was driving,
A rental
a
vehicle?
rental vehicle.
And was it like a storage vehicle, like a Ryder truck, or was it a Hertz rental car, or can you tell?
No, it was an actual vehicle. I can't remember what the make and model was. But we did follow him over to it was either a Sam's or a Costco or something like that.
You saw him leave the residence?
Yes.
In the rental vehicle,
Mhm.
go to Sam's or Costco and then return to the vehicle, return to the residence, or did you follow him back?
At that point, he met with somebody, but we had to pull off. We didn't have enough people to continue the surveillance.
And you don't recall what day that was?
No, I don't.
Fair to say it was before the controlled buy?
Yes,
Okay. And then the controlled buy, do you know the date that occurred?
I don't recall.
Okay. And if all this is better information for Perez, to get information from Perez, just tell me. But it says the control buy was done. You said you surveilled that yourself?
Yes, I was in the parking lot.
You don't recall the day of that, though? You don't recall if it was on the 29th, in fact, the day the warrant was obtained?
I don't recall. I don't remember.
Okay. So, you don't have any notes of that to refresh your recollection?
No, I don't, not here.
All right, let me ask you this. As it relates to the control buy, you said you were in the parking lot.
Yes,
What was the location where the control buy occurred?
the CVS parking lot at Hardy Oaks and Wilderness Oak.
And how did the control occur? Was it between cars, people get out of the cars? How did that work?
Ms. Reyes exited the vehicle and went into our confidential informant's vehicle.
Okay. And after that, obviously you saw her, I take it, get out of a vehicle and get into the confidential informant's vehicle, right? And then how long was she in there before she exited the vehicle, if she did?
It was a few minutes, maybe 5-10 minutes tops.
And when she got out of the vehicle, what did you do to confirm the control buy?
We met up with our informant in the same parking lot,
And did he have, was it a male or a female?
the male.
And did that person have money on them, cocaine on, or methamphetamine on them, or anything like that?
You mean after the purchase?
Yes.
Yes,
And what did he have?
methamphetamine.
All right, so he bought methamphetamine. It was a controlled buy. He was buying methamphetamine from Phil Reyes.
Yes,
Do you know how much methamphetamine Phil Reyes had when she entered the confidential informant's car?
no, I don't.
Do you know how much, if any, methamphetamine she had when she left the vehicle?
No, I do not.
Do you know how much he paid for the methamphetamine?
I do not recall.
Did you know at that time?
No.
You didn't know if it was a $20 bag or?
Yes, I did, but I don't remember what the amount that we purchased.
Nor you don't know the dollar amount, and you don't know the weight of what he purchased?
Yes,
Okay, how much did he purchase?
I don't remember.
And then after the buy, did you surveil Ms. Reyes back to the residence?
Yes,
Okay, and before the buy, I take it were you on surveillance then?
yes,
And did you see her leave that residence?
I did not.
And was that because it was rolling surveillance and somebody had relayed that information to you?
Yes,
And so y'all were specifically following Phil Reyes, correct?
correct.
And did you ever follow or see John? You mentioned John Meyer just that once before. He didn't leave the house that day.
No,
And were there vehicles at the house other than Miss Reyes's vehicle?
I believe so.
Okay, and do you know who the owner was or the rental person was of those vehicles?
I don't recall.
Okay, do you recall how many vehicles there were?
No, sir.
You mentioned that when you executed the search warrant, you did not have a body cam, is that right?
Correct.
Okay. May I approach Judge?
Yes.
And do you want me to ask to approach?
No, you do not have to ask to approach.
Let me show you here, Deputy Rios, this document that was prepared in relation to the investigation of this case. Do you see that? Do you recognize that?
Yes.
And do you see where it says your name
Mm-hmm.
and next to it, it has body cam
Mhm.
checked? Does that refresh your memory as to whether or not you had a body cam on that day?
I don't remember. But I mean, that says I have a body cam, but I don't remember if I had one on, but usually we do not.
Okay, now we're not talking about when you're talking about when you're executing the search warrant.
Right.
When you're executing the search warrant, there's no need for confidentiality or not having on your uniform, correct?
Mhm.
So, but you don't recall wearing a body worn camera?
No,
But you normally do not in
do
those
not,
situations?
do not,
Okay,
not in uniform. I mean, not out of uniform.
so whether you're in uniform or not is what controls the body cam, not the undertaking that you're pursuing at the time, correct?
Correct.
But now that you've seen this, you think that you might have had a body cam.
It's on the form.
Did you fill out the form?
No,
Do you know who filled out the form?
I do not.
Is the information on those forms typically correct and accurate?
Yes.
Okay. So you received information that Phil Reyes left the residence. Did you know if she had any type of items with her? Did she have a purse or a box or anything, or do you know?
I don't recall.
When she went back into the house after the controlled buy, did she take in the house anything with her, like a purse or a box or anything of that nature?
I don't recall.
And you said that, I'm gonna jump ahead now, I take it you saw her go back into the house on the 29th, October the 29th, or are you unsure about that date?
No, the date of the control by, yes, she did go back to the house.
I understand that, but I'm asking you what specific date that was. Was that October the 29th?
I'm assuming so, yes. I don't know the exact date.
Okay. Let me just run through this scenario where you can see if it helps you with your dates, okay? The warrant first mentions October the 26th. And then the warrant mentions a control buy, and the warrant was in fact sought and obtained on October the 29th. Can you tell me if the date the warrant was sought and obtained was the same day as the control buy?
I cannot. I don't remember.
All right. And then, but the warrant was not executed until 3 days later on November the 1st. You agree with that?
Yes.
Okay. So let's just go to the November 1st date. You recall what time of day the warrant was executed?
It was during the day. It was during the day.
And did you say that you did not conduct the search of the residence, correct?
No, right, correct.
But you did help secure the individuals who were inside the residence.
Correct.
Right? And did you also interview those individuals in relation to the execution of the warrant, or ask if they wanted to talk to you?
Correct.
Okay. How many individuals were inside the residence?
But I can remember at least 3.
And prior to the execution of the warrant, had you had the location under surveillance?
Yes,
And you know if John Meyer was in the house from him, seeing him coming or going or anything of that nature prior to the execution of the warrant on November the 1st?
not that I remember, no.
Hadn't seen him coming or going from the residence that day, correct?
No.
When you first got there, were you greeted by an individual by the name of Sparks, or do you recall?
Yes,
And do you recall, does P16 is a black and white photograph of an individual? Does that appear to you to be Mr. Sparks that was at the house?
yes,
Okay, that's an accurate picture. I know it's black and white. We don't do that much these days, but that's an accurate picture.
yes, sir.
Okay. And then when you went inside the house, did you also secure a back bedroom?
When I made that back bedroom, it was already empty.
Okay, when you made the back bedroom, when you say it's already empty, that means nobody was back there?
Correct.
And does that back room, is that the master bedroom?
Yes,
And was the master bathroom occupied or unoccupied?
I don't know.
Nobody would, I'm sorry, not before, but when you went in there, nobody was in the master bedroom or the master bathroom. Is that correct?
Correct.
Okay, I'm showing you defendant's exhibit P15 and ask you if you recognize the individual in that picture.
Yes,
Okay, and is that Miss Reyes?
yes,
Okay. And do you recognize that as being a picture taken of her in that back bedroom?
it looks like it, yes.
Okay, and both of these are accurate photographs?
Yes, sir.
We would offer P15 and P16, Judge. Yes. I do not. Mark knows. Yeah, I guess because he says he didn't have.
All right, any objections to defense exhibit P15 and P16?
This is this. Something.
No objection, Your Honor.
All right, then, defense exhibit P15 and P16 are admitted.
Thank you. And let me ask you about Mr. Meyer. Did you see him inside the residence on November the 1st when you executed the warrant?
Yes,
Okay, and where was he?
I want to say it was in the closer to the front door, like den living room area between the kitchen.
If you walk in the front door and immediately to your right is a den living room area, correct?
Yes,
And isn't that where Mr. Meyer was?
yes,
Okay. And did you understand that Miss Reyes was in fact in the back master bedroom when y'all entered the house?
no,
You didn't understand that?
no, sir.
Okay. And then, so did you interview Miss Reyes?
Yes,
And did you interview Mr. Sparks?
yes,
And after you did that, you said that you didn't search the house. What did you do?
I just stood by until the search was conducted.
Now, I've got a report where you indicate that certain items are found inside the residence. And did you actually see these items in the residence? Or did somebody tell you about where the items were?
Most likely I would have been told.
This is your report. And I'm talking about these items listed here and here. Do you recall if you seized those inside the house or somebody told you where they were located?
I remember seeing that when clearing the rifle,
Yes.
I noticed that.
Okay.
But the other items I did not discover. I was told.
So specifically, what items did you take from seize inside the residence? Do you recall?
That would have been the evidence tech. I didn't seize any of the items.
Okay. No, let me ask you this. Did we go through this?
All right, while the defense is discussing that, Ms. Ferguson, there are 3 people here who were not on the docket. Okay, awesome. All right, thank you. All right. Defense, are you ready?
Yes, ma'am.
All right, you may proceed.
Officer Reyes, let me show you a report. I keep calling you Reyes. I apologize. It's
Okay,
Rio.
all right.
All right, let me show you this report and ask you, this is prepared by you, correct?
Yes,
Does this refresh your memory as to where John Meyer was?
yes.
And where was Mr. Meyer?
In that living room den area.
Okay. And does it refresh your memory as to where Miss Reyes was?
Yes, she was in the living room den area.
Okay. And is it possible that she was in a different location of the house before she was taken to the den area?
Yes.
Okay. The surveillance prior to the execution of the search warrant on November the 1st, did you engage in that surveillance?
Yes.
And you know how long that surveillance took before the execution of the warrant?
I don't recall.
Was it hours or do you have any idea?
Most likely a few hours at least.
Judge, if I might have just a moment.
Yes.
Do you recall there being drugs alleged to be methamphetamine that were found in the back bedroom?
If there was, I did not discover them.
see if that refreshes your memory.
Yes,
Do you recall now that drugs were seized from the back bedroom?
yes,
Did you seize those?
I do not.
Let me ask you a question. On the execution of the warrant, I'm talking about literally going in the front door of the residence on Majestic Drive. Can you tell me where you were? Were you the first one in, second one in? Can you tell me the order of the officers that proceeded inside the residence?
It would have been the entry team,
Yes,
which is comprised of SWAT officers, SWAT deputies. I would have been on the outside until the house is cleared. Everybody's detained.
and typically, when the SWAT officers go in, do they gather up all the residents and put them in one location?
Yes,
And then y'all enter?
yes,
And so, okay. But the picture of Mr. Sparks is outside the residence.
yes.
Do you know how that occurred, how he was taken outside the residence?
I believe when they knocked and announced he opened the door, so he was first to make contact with. So they had him, they pulled him outside.
Okay. Anything else? I'll pass the witness, Judge.
No further questions from the state, Your Honor.
All right, is this witness excused?
Yes, Your Honor.
Defense, is this,
I think maybe he'd be around for recall.
all right.
May need him.
All right, the rule has been invoked. What that means is you can't discuss your testimony with anyone except for attorneys for the state or the defense. Make sure you're available if either party wishes to recall you. All right, you may step down. All right, off the record for a moment. Any defense attorney who's present, who's ready on their case, you can approach the court coordinator and she'll have your file pulled and we'll take you up very quickly.
Thank you.
And so state of defense, we're going to take 5 minutes
Yes, ma'am.
break on this.
Yes, sir.
And if anyone needs to confer with one of the prosecutors at the table, now's the time to do so. And Norman, could I see the file on Jesus Lopez as well? Yes, I see the reset date for April 18th. I want to just make sure it's in the file. Okay. Oh, then we're good. Okay. All right. All right. All right, yes. Yes. All right.
I don't see Mr.
All right.
That's his. Oh, you got one.
Yeah.
Yeah, see this.
I believe he's in the back. Yes. Oh, but I can have another prosecutor stand in if you want it on the, so it can be on the record for you. All right, could I have a prosecutor just briefly stand in for the court's ruling on this motion?
Sure, Judge.
Marietta?
Are you ready to go on the record? Is he in the back? He's right there. Mr. Hennerho, if you'll come down. All right, we're going to go on the record. Court is calling 2020 CR 10218, State of Texas versus Jesse N.O. Can I have parties announced for the record for the state,
Daniel Barr for the state of Texas.
for the defense?
John.
All right, Mr. N.O., I want to let you know that I reviewed all of the case law that was presented by your attorney, also presented by the state. And based upon everything that I've heard, we were here for the hearing on the motion for new trial. The court is going to deny the motion for new trial. Is there anything else from either side? All right, thank you.
Have a seat, sir.
Let me see. Mhm. No, it's not in here because this is a duplicate. Yes. Yes.
Israel Fuentes Gonzalez. Video.
Victoria Velez. All right, you need to be seated on the front row. Lyria Labarde. All right, first row. Israel Fuentes Gonzalez. Israel Fuentes Gonzalez. All right, April Perez. April Ann Perez. Elisa Hernandez. Gilbert Perryman.
Here, you're right, late.
All right, front row.
That's included. Nathan Bates.
Eduardo Reyes. Priscilla Para. Jesus Rivera. Juries Deek.
Karen Moreno. Anita Hernandez. April Perez. Larietta Holmes. Israel Gonzalez.
Bring the people you got in the back. Okay. The three I leave left.
All right, anybody ready to approach? All right, you need to have them pull your file and I'll take it up.
Thank you.
Bobby Rivera, come forward. Good morning. How you doing? Oh, okay. Thank you for dressing appropriately for court. All right. All right, today is the plea deadline date. Okay. I think that order to substitute has already, let me see if it's been signed. Ah, I'll sign it now. Do you have any objections to this attorney substituting in?
Yeah, sure.
All right. All right, so I'm going to extend your plea deadline date. This will be the last extension. Ms. Ferguson, on this case, can you put it the week of May 13th, please?
This is what there's violation. So I see two cases. Yeah, there's two cases. Yeah, so let's see.
All right, that will be your final plea deadline date. Just sign the reset form with Ms. Ferguson, then you're excused, and make sure you confer with the state and review their file. All right, thank you.
Still on the one. I don't see it.
Okay.
No, I'm gonna just triple check, make sure all is here.
You know what? I'm gonna take a picture of it and my mom will be able to tell me when I send it to her. Okay, all right, so I'll take a picture of it and my mom will be able to tell me who it is. All right. Chastity Natal?
I'm present on that, Judge.
All right, have you received all the discovery?
I have, Judge, I was just gonna ask, I'm doing San Marcos, I was just gonna ask for the recall it, because I guess y'all are.
No, when
Thursday and Friday, or Thursday all day, was gonna see if we need to be tomorrow or Friday, so I can confirm.
we can do it Thursday.
But I'm.
Okay, Thursday. Tomorrow's not good. I can recall it for the end of April. All right, Ms. Ferguson, on Chastity Natal, can we put this for April, the week of April 29th?
Waste of time. I go where? You're in the right place, but they're in a hearing room. As soon as they're done, I'm sure they'll. Can I just leave it there? You can.
All right, May 2nd.
Yes, ma'am, thank you very much.
All right, once she signs the reset form, you're all excused.
Something like that. Okay.
All right, anyone else who's ready? And I think Mr. Stevenson is reviewing something. Well, Mr. Stevens. Yes. All right, could I see the file? All right, could I see the file on a Gary, please? Yes, Alejo. So that's where the EMS was for?
Yes, you heard it.
Mhm. All right, state on Alejo Aguirre, that's criminal trial division. That's gonna be recalled. He had a medical issue, the defendant. All right, Ms. Ferguson, if you can recall this, the end, well, the first or second week of May, please. All right. Probation, Aguirre is being reset for May 2nd.
We appreciate it. Absolutely.
All right, could I see the file on David Vargas, please?
Judge, let me grab it, give his attorney to come.
Okay. All right, everyone, you're gonna have to move with the purpose while the defense is reviewing things with the state on this hearing, because we're gonna take this hearing back up.
If you need that, go ahead. Just go through.
Hi, all right. All right, Miguel Perez Narano.
Yes, sir.
All right.
We're here, the case just recently got indicted, Your Honor, and I was, I'm lost, so we're telling me how to do the discovery process, so.
Okay. All right, y'all, and which prosecutor were you speaking with? Hi. All right, so I'm gonna reset this. You are gonna have to off docket. I'm sure you have his contact information. He'll be able to give you an offer off docket, okay? All right, Ms. Fergus, can I have a 30-day reset on Perez Narano, please? All right, we're gonna come back on May 23rd. At that time, you need to let the court know whether or not you're gonna be accepting the offer that's been presented by the state. Do you understand? All right, thank you for addressing appropriately for court. Once you sign the reset form, you're excused.
Thank you.
You're welcome. Okay. Okay,
And
good morning. Just give me a moment.
I'm hearing an docket too on that mess. It's like a no, it's not.
Okay.
Well,
Okay. Is there a case or is it an MTR?
no, it's a case.
Okay. You just want to pull the file?
Yes.
I can give you an offer.
Yes.
Okay, let me just find which page he is on. All right, thank you.
Okay. You want to give me an offer? Or? Okay. Oh, sorry.
And could I have the file on Vargas?
Yeah, both of us. Hey,
Okay, thank you. So they're gonna get it, then we'll take it out. Jose Amador.
Young President, Firm Judge, I'm asking to stay.
All right, Jose Amador, come forward.
This is.
Where is he?
Correct, not a name for this one.
All right, can you guys
On this
ask the
one,
deputy to bring him up and I'll take it up?
This is two weeks ago, it's still out there, and I don't know why, so. It doesn't matter. It was done yesterday. It was done yesterday, so just.
David Vargas.
This case is. We'll just put it over.
All right, we're gonna go back, we're gonna go on the record. And if you all could, yeah.
Yes.
All right, we're on the record. Everyone please whisper. In 2018 CR 5087, State of Texas versus David Vargas. Can I have parties announced for the record for the state?
Spoken to the state, Your Honor.
All right, and are you Mr. Vargas?
Yes, Your
All right, so with regards to this case, the court had ordered that the defendant be taken into custody and then to SATF or even felony drug court and to remain in custody until transfer. I had requested from probation if they had any input or information from the court. Probation said no. But then probation is now telling me that they have other information in probation. What is the information?
Your Honor, I do want to apologize on the record for yesterday. I would like to see if we could possibly do something different than the ruling yesterday. And I would like to see if we can do the TAP recommendation, follow all recommendations of that TAP, a felony drug court referral, over the court meetings, you and hotline, and the initial interlock from vehicle.
All right.
I don't know what the outcome of the other case in the other court might be.
Yeah, I saw that.
But I think if we start with this route, we could get him the necessary help that he needs.
All right, and the court will note the defendant has been on probation since May 28, 2019, and this is the first motion to revoke. And also, state and defense, just so you're aware, probation did inform me of the medical, I don't call them issues, but the medical treatment that's required of him that they're not going to be able to address if he's taken into jail. And that treatment involves treatment for his diabetes, and it's by injection, and the jail does not do that. And I think, as we all know, if your diabetes are not monitored and if you're not following the protocol, then that could result in death. And this one, he has an alleged new DWI that he hasn't pled true to here, but he did plead true to the driving while license invalid. So this is what the court is going to do. As previously stated, the court did deny the motion in alternate main conditions. So there is to be ignition interlock until further notice. I'm going to ask for a TAP evaluation out of custody. There is to be a referral to felony drug court. Do not miss that appointment with felony drug court. If you miss that appointment with felony drug court, I'm going to get a report that you missed it. I'm going to ask probation to file a motion to revoke. And then, if you end up at the jail and they're not giving you your medications, that will be between you and the Bexar County Jail. You understand? There's going to be 90 sober meetings in 90 days. And that ignition interlock needs to be in place no later than Friday. Now, if for some reason they can't put it on Friday, oh, he already has it? Okay. All right. So no later than Friday. Now, note for the record that your defense counsel is saying that you already have ignition interlock. All right. And then follow TAP recommendations. I really do think that felony drug court would be the best fit for you. So you need to let them know what your issues are. All right. Because you have a pending DWI. I'm not saying it's true or not true, but it's a misdemeanor DWI. So allegedly, if you have a DWI and you're looking at 10 years, that's not good. You understand? All right. Is there anything else?
20.
Yes, I'm sorry. Yes, 20 years. He's on deferred for 10 years. Oh, so there we go. It may not be a DWI. There's still that, and there still means that you're alleged to have been drinking alcohol while you're on probation. And as I tell everybody, when you're on probation, you're not allowed to drink alcohol. You're not allowed to smoke marijuana. These are not my rules. That's the legislature. Understand?
I think ask that, so on the record that we do the TAP as a rush.
All right. I'll ask for the TAP to be expedited. All right. Is there anything else? All right. Thank you for dressing appropriately for court. Do better. Welcome. Yes. All right. Matthew Trevino. Matthew Trevino.
You don't have to tell me at all. Okay.
Hello.
Okay.
So why are we here with Mr. Trevino?
Status report, send it to the court.
Yes.
Instead of signing the report, you ask this device, but in the report, it indicated Mr. Trevino had not completed yet.
Mhm.
Actually has.
And they won't do the drug test.
It was the,
Yes, I accepted it.
okay, so that was the original.
Okay.
Inquiry. Because Mr. Daniel was not submitted a UA, he was going to submit either today or tomorrow. I did request a UA from him today, and unfortunately that did come up positive for marijuana. He's completed everything else on probation with the exception of his fees. And I believe Mr. Daniel would like to address the court,
Yes.
and you gotta speak up.
Yes. Sorry, I couldn't pay the hard fees. A lot of them.
All right, so here's the thing. With regards to court fees, everybody knows in this court that I understand that sometimes people can't pay their court fees because the issue is, do I pay my court fees or do I buy food or do I have a place to stay? I understand that. The issue with you now is that UA. So what's happening with that? Well, I mean, why are you doing that when you know you're looking at a year in the Bear County Jail? All right, so what are you sad about? What's going on?
Second of all, maybe being able to pay, of course, that's part of probation, but that makes me kind of upset that I can't. The extension of the year and all of that, which has nothing to do with probation, but of course, I have a girlfriend for many years. She had me.
All right, so how old are you? All right, at some point in time, people, maybe relationships are meant to be, maybe they're not. Sometimes relationships are for a season. And you got to accept when something ends. And you know what? When something ends, it opens up the door for new beginnings. So here's what we're going to do. You expire May 19th. I can't extend you any further. But this is what's going to happen. You're going to present yourself in this court.
I'll sit right here.
May 18th. Oh, sorry, just 1 second. Not May 18th. That's a Saturday. You're going to present yourself in this court on May 16th. And you better be negative. Do you understand? All right. Is there and if you have issues with depression or anything else like that that's going on, or you just need somebody to talk to, call your probation officer. They'll get you in contact with somebody who can work with you on that. Do you understand? All right, so you're going to sign the reset form. We're going to have you back here on May 16th, and you had better be negative. You understand? All right, is there anything else? All right, thank you for addressing appropriately for court. Norma, on Matthew Trevino, he's coming back on May 16th.
This is.
Mhm. Yes. Yes.
Something like a.
All right, if you bring him up.
Okay.
Okay. Yeah. All right, Jose Amador, where are we?
Judge, I have some outstanding discovery of request. State files are too large to download.
All right, Ms. Ferguson, on Amador, can I have a 30-day reset for discovery?
Okay. It's a probable. Okay.
21st.
May 21st, council?
That works, Judge.
All right, we'll be back on the 21st. So all the discovery is uploaded is just too much to download?
Yes, Judge, and there's multiple cases. I know that defense did give me a list of the videos that did come up as too large to download over the discovery. Focus on those. If there's anything else, I can speak with defense.
Yeah.
All right, do you have any questions, Mr. Amador?
Not a cap. That's it.
All right, then we will see you back here on May 21st. Is there a chance that he's going to be released?
I do not.
All right, you need to be back here on May 21st. You understand?
Yes,
If
ma'am.
you're in custody, we'll have you brought over.
Maybe we be excused.
Yes. Okay.
I didn't want to say it.
Nathan Bates.
I know there's a lot in my eyes.
Hello. Thank you for dressing appropriately for court. All right, so what's happening with this case?
Yes, first sitting on this matter, I did review the discovery and there is an outstanding co-ban. There's Lloyd Cuellar and Anthony Brown, which I requested of the state, so hopefully produce.
All right, Ms. Ferguson, can I have a 30-day reset on Nathan Bates for discovery?
She'll probably just go to normal.
Is that enough time, state?
Yes, Your Honor, we appreciate it. Thank you.
Yes.
However.
All right, we'll come back on May 21st. Oh, happy birth month. Once you sign the reset form, we will, you're excused.
Thank you, Judge.
All right, so May 21st, you will celebrate part of your day with us. All right, thank you.
She's gonna kill it.
Be with you right shortly, Nathan, right?
She's not for 10 over. Over 10.
All right, who's here on Elisa Hernandez? He's not here.
Left her message yesterday.
All right,
That's all we got.
can you all check to see if there's a PR bond or commercial bond? Cost number is 2024 CR 2852. Could I have a prosecutor, please? Court is calling 2024 CR 2852, State of Texas versus Elisa Hernandez. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Ed Piper present for Ms. Hernandez.
All right, this hearing was scheduled at 9 a.m. It is now 10:40 a.m. The defendant has not made an appearance. Defense, do you have any idea where your client is?
But we do have a good phone number for her. We did call her yesterday and left a message, but I don't see her for today, and she didn't answer my call when I called the name.
All right, clerk, is this a PR bond or commercial bond? All right, state,
State's requesting a bond forfeiture.
that'll be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you.
All right, thank you.
Have a good day. What is it, MTR? Yeah, sorry.
Michael Reams.
Oh, Michael, go for it.
All right, what is happening with this case?
If we do have an offer from the state now, it's our first setting. I'm asking for one reset to go over the evidence with my client a little bit more.
All right, do you have all the discovery?
I do now.
All right, Ms. Ferguson or Michael Reams. How old are you, sir?
42.
All right, can I have a 30-day reset for a plea deadline date, please? All right, May 21st, once you sign the reset form, you will be excused. On that date, you need to let the court know whether or not you're accepting the state's offer. Do you understand? All right, thank you. Brandon Diaz.
You're on.
Good morning. Where's Mr. Diaz? How are you doing?
Pretty good. How are you doing?
Oh, I'm doing great. It's juggling balls, but that's okay.
Herding cats.
Yeah, there you go. All right, do you have all the discovery?
Yes, well, here's the other thing. Say yes right now, but right now I'm asking for a reset to get some mitigation evidence put together.
Okay.
Make our first set.
So is there any Child Protective Services records in this?
Not that I'm aware of.
State. It's family violence.
Yep, I got you.
Or in this case, endangering a child. Do you know if there are Child Protective Services records?
We have not confirmed much, so I'm not sure.
All right, was CPS called in your case? You, Mr. Diaz.
Yes, I believe so, and then they close it out.
All right, so there's CPS records.
I'm happy to confirm. I don't even know the case, right? I apologize. We haven't spoken.
You know, I require people to confer.
Yes, Your Honor.
All right, so just confer briefly with the state and see what kind of offer they're gonna give you, and then if they want to give an offer today, and then come back, we'll take it up. Lirio Labardi. Hello. Mom always likes seeing you.
Hi. That's why I came in here, because those are actually out of your court. So I was like, I'm just. gonna
Oh,
avoid this.
thank you. There you are. Have a good one. All right, have you all conferred with the state?
We have, Your Honor.
You have all the discovery?
We do, Your Honor.
Was an offer tendered?
Yes, and we would just need a 2-week reset. Mr. Forty is in the process of moving, so she needs to get her housing situation taken care of. And she was actually late today, Judge. There was a big accident on 10.
Okay.
Judge Mesa was late. Ashley was late, several.
So basically, you're just throwing
I
down
am.
people's name with judge. President was late.
He was.
Uh,
He was coming to my house to.
The chief was late.
But basically, that was the situation. That's what she.
Judge Boyd was on time.
She had actually texted me at right before 9 o'clock to come. She was on an Uber.
Yeah, it happens.
Judge, I'm sorry. I needed to order a little bit earlier because of traffic and I apologize.
No,
That's
here's
on
the
me.
thing, stuff happens.
Yeah.
Sometimes there's an accident. He's joking with me, so I'm joking with him. All right, so, Ms. Ferguson, on this, they want a 2-week reset.
That's fine. April 30th, because I've got about 3 or 4 things on between that.
All right, April 30th would be your plea deadline date, and you'll need to let the court know if you're accepting the state's offer. Do you understand?
Yes, ma'am.
All right, once you sign the reset form, you are excused.
Thank you, Your Honor.
You're welcome. Thank you for dressing appropriately. Yes.
I just made phone contact with my client, Marissa Hernandez. She's on a lift. She got like a Uber lift. She's in Santa Rosa and something. I told her to come to your court and report
All
in.
right.
I'll be allowed.
But you'll let them know so they won't put it in the system just now. Israel Fuentes Gonzalez.
President, Your Honor.
He's not here? Is he in custody?
Judge, apparently, my client's not present, but I have a good faith belief he's somewhere in the state of Texas. Yeah, since the court has jurisdiction throughout Texas.
All right.
That's good.
Court is calling 2024 CR 1478, State of Texas versus Israel Renee Fuentes Gonzalez. Could I have parties announced for the record for the state?
Hank Wilkins for the state.
Defense?
Michael DeLeon for Mr. Gonzalez.
This hearing was scheduled at 9 a.m. It is now 10:46 a.m. Deputy has informed the court that there was an announcement made in the hallway and the defendant was not present. Defense, do you know where your client is?
I have no idea, Your Honor.
Somewhere in the state of Texas. That's what
Somewhere
you,
in the state of Texas is a reasonable belief.
all right. State,
Your Honor, we're asking for a bond forfeiture.
that'll be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Your Honor.
All right, thank you. Have a great day.
Excuse me.
Yes. All right, everyone. Brandon Diaz, have you all conferred? All right, so are you all ready?
Oh, yes, ma'am.
All right, counsel, you're approaching.
Is it?
Go back into this hearing. If you want to approach, you need to have them pull the file. Did you confer with the state and receive an offer, Mr. Cox? All right. Oh, it's Jason. They're not, Jason is not in this hearing, so y'all can still confer with him. What?
I would.
All right, everyone, I'm gonna let you all continue to confer. No, if you're ready to approach the court, you just need to have them pull a file.
Okay, that works.
Oh, yeah. The rules here are very simple.
Those are the hardest ones to call. Don't you know that by now?
They are.
Just looking at it, I sort of agree with you. Yes.
Karen Marino.
This is it.
Okay. Are you all ready to proceed on the motion to revoke?
We're ready to, I guess, make an announcement.
All right, so what's going on?
So she has a new number one, a misdemeanor that I do not represent her on.
Mhm.
At this time, I may talk to that attorney to see if I could get on that case just to do a better job representing her on this enter, but at this point, the state's not ready. You know, we're not ready to plead true to the new number one, obviously. So we would either pass just for an extended reset. We have a
Okay.
court date in early May on the.
All right, so why were you late for court?
Today.
Yes, this courtroom, you were not here at 9 a.m. Why were you late?
Because I didn't know what courtroom was it. I had to go on my phone and look for the courtroom.
Yeah.
Okay, you've been here before.
But not on this one.
Okay. All right, now you know where it is. Don't be late again, okay? That's yes or no.
Yes.
Look what I circled.
When I was growing up, my mom would always tell us, don't say, mhm, mhm. I did that once in front of a doctor when I want to say I was 5. Afterwards, my mom had a long conversation with me. She said, when somebody asks you a question, you need to look them in the eye. You either need to say yes or no. She's like, I didn't teach you to say, I'm sorry, Mom. And then afterwards, she gave me zebra gum. Whenever we would get zebra gum or cinnamon gum, that means that you're either going to the doctor's, because that's sort of like a treat. So you would be on high alert. Oh, all right. So Ms. Ferguson, on this, just set it for a contested hearing.
Never even seen it.
And it won't be contested unless y'all want to contest it.
Right, okay.
All right, May 13th. And then with your setting in the, with the setting in the other court, if you work things out before then and you want to come back here before that date, you're more than welcome to come back before that date.
Thank you.
All right, thank you. Have a good one. Once she signs the reset form, she's excused.
Wonderful, thank you.
All right, have them grab your file and then we're going to take up the other case.
Is it dismissed?
Oh, look at you. All right, Mr. Tyson. Well, Jason, before you sign off on that, Mr. Tyson, come forward. Hold off on signing that.
Judge.
Why are you late for court? No,
When you call my name and everything.
no.
Yes, ma'am.
I'm out of it.
I'm gonna call my protector.
Okay. He may have been here on the recall, but not the first call. Because I always do a first call exactly at 9, and then I do a recall. Because otherwise,
Well, when they let us in.
I will write that down.
You see when they let them in.
All right, State, do you have something for the court? All right. Thank you. Thank you. All right, your case has been dismissed. Thank you for dressing appropriately for court. All right, so here's the thing. The state ends up dismissing this case. Your attorney knows the reason for the dismissal. Whatever brought you here, don't come back here for this. You understand? All right, good luck to you, okay? And don't go out celebrating.
No, ma'am, I gotta work.
Okay.
Congratulations.
Yes.
Brandon Diaz.
Brandon Diaz. All right, did you confer with the state? received an offer?
No, Your Honor. Just like, counsel had mentioned when he had first spoken with Your Honor, we're in the process of getting one additional body worn camera video. And we need to make a quick request for, well, quick is the goal, Your Honor, for CPS records. They only filed the CPS records at the moment of the alleged incident. There wasn't a pre-existing CPS investigation or record.
Okay. All right, Ms. Ferguson on DS. Can I get a 45-day reset? And you all will need to confer off docket.
Yes, sir. Thank you, Judge.
All right, you're welcome. All right, May 30th. Once you sign the reset form, you're excused. All right. Everyone, you all can continue to confer. We're gonna go back on the record on this case. Or if you could move Ms. Thorne and her client down to the other end. We're gonna go back on the record in 2024 CR 0170, State of Texas versus John Meyer. State, call your next witness.
State calls Deputy Martin Perez.
Your Honor, before he testifies, could we just remind the court that we have objected to admission of any of the evidence found by, and I think Mr. Perez is the evidence custodian. So we made those objections previously pursuant to the Texas Code of Criminal Procedure and the federal and state constitutions, Your Honor, specifically Article 38.23A, 18.01B, 4th and 14th Amendments, and Article 1, Section 9. We would like it. I know the court doesn't like continuing objections, but I feel like we've made.
I'm fine with continuing objections if that's how you all wish to proceed.
I just so the objections are clear.
All right. And with regards to this witness, the evidence he's bringing is related to the search warrant that the court just ruled upon. Is that correct?
Yes, Your Honor.
All right. All right, could you raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record, please.
Martin R. Bettis.
All right, state.
Deputy Perez, how long have you been a sheriff's deputy?
25 and a half years.
And that's with the Bexar County Sheriff's Department?
Yes, sir.
Do you have a specialized training to be a police officer?
Yes, I do.
And are you a certified peace officer?
Yes, sir.
You weren't involved in the search that was the subject of the guilt innocence phase of this trial. Were you the search of 224 Majestic Grove in August of 2022, right?
Yes, sir.
You were not involved in the August search.
I'm sorry. What was that?
No, I phrased that weird. So you weren't involved in the August search, but you were involved in the November search. Is that right?
Yes, sir. The second one.
Okay. And what was your first involvement with this case?
I was tasked with the purchase of narcotics by way of a confidential informant and also by actually writing the narcotic search warrant for the property.
Okay. And so how does that work when you're trying to get the confidential informant to buy the drugs? What was your first step there?
One of the first steps that we do is a controlled buy. Usually that's done obviously before a narcotic search warrant is executed, but it's a grounds for an affidavit and for the warrant to be written. We'll purchase usually a small purchase of narcotics off-site that's leading to surveillance, the control buy with monies that were provided by the county through our narcotics unit to purchase those narcotics.
And so were you involved in the surveillance on 224 Majestic Grove before that?
Yes, sir.
Do you remember what day you started helping out with surveillance over there?
I believe prior, maybe a couple of days, not more than that, with the surveillance. And my job on the surveillance was more of the exterior, kind of the outer perimeter of the neighborhood.
So were you, your duty was to watch the house or to watch people? What was your duty of the surveillance?
It was a gated community, so I was kind of more or less established out with the, I believe it was the main gate. I believe it was only one way in, one way out. So I didn't have eyes on the property itself, But if anybody leaving the property by vehicle, there's where I was tasked with, we call it rolling surveillance by vehicle. And I would just wait for the word either by the other deputies that were actually watching the property.
So you were doing rolling surveillance?
Yes, sir, that's what we call it.
And did you do rolling surveillance on an individual involved in this case?
No, I didn't have to. I didn't have to leave where I was stationed, which is pretty much right across the street from the main gate.
And you did a controlled buy as part of this investigation?
Yes, sir. There's where I was tasked with the control by with the confidential informant that I had under my authority.
Okay, and so your confidential informant, what did he do to initiate this deal?
Made contact by the seller via, I believe it was through social media or something with by cell phone and text, which led to text messages eventually. He set up the actual buy for us to lead the seller from the property to where the meet location would be.
Okay. And so this person was a confidential informant. And who were they going to buy the drugs from? The defendant?
No, not from the defendant. It was, I guess, his co-defendant, female.
And so how does a controlled buy work? What are the steps that y'all take?
So the steps that we take initially, and I'll just kind of walk you through it, is we'll meet with the confidential informant prior. I'll give him specific orders, which directions, instructions that he needs to follow by the T. We'll also conduct a pat down of the confidential informant, make sure he doesn't have any narcotics, contraband, or weapons. And they've all been made fully aware of this prior. I also check the vehicle to make sure there's no narcotics or contraband or weapons in his vehicle. And then we kind of go through what I need him to do. Hey, we're going to go to this location here. You're going to meet with the seller here. This is what you're going to give the seller. In this case, I can't remember the exact amount of US currency that we give him, but we do provide the funds. See, confidential informant doesn't provide any funds of his own. I give him a specific amount of money. He gives that to the seller. The exchange is made. In this case, in the parking lot that was right across the street. And then he gets the narcotics, and then we meet at the same location that we met prior. I receive the narcotics and any other intel that I can get from the confidential informant. In this case, also, the seller did seller confidential informant narcotics, at which point she was also surveyed from where the start point to the end point, and in this case, she returned back to the original point.
Okay, so who is David Alderete involved in this?
That one I have no familiarity with. I believe that was from the first time. I had no contact with him, so I couldn't tell you that, sir.
Did your CI talk to David Alderete? Did he make the introduction to the CI between PETA and the CI?
That one, I'm not sure how the process took place on that one.
Okay, so but you or members of your team surveilled Ms. Reyes leaving the location, and then where did y'all go to do the controlled buy?
Okay, so in this case, from the start point, which would be the property on Majestic Road, she leaves the property there. She's under surveillance. She's followed out the gate. At that point, where I'm stationed is I can see her coming out the gate into our meet location, which was at CVS parking lot. There's where the buy was conducted, and from there we survey not only just for intelligence purposes, but also for the protection of the confidential informant. Also, because we still have a duty and obligation to protect that confidential informant.
Okay, and so they meet up, and what did the confidential informant bought the drugs from Ms. Reyes?
Yes, sir.
And then what's the next step?
So once the buy is conducted, the way that we have knowledge of is when Ms. Reyes drives off, confidential informant still waits. We still actually met maybe a couple of rows down, but we still stayed in the same parking lot. Confidential informant pretty confident that we don't need to go anywhere else. At that point, he gives me the narcotics and then whatever intel or information he has. I always like to ask, what did you guys talk about? The conversation was real short. I just remember him saying something.
Objection, Your Honor, to hearsay.
Sustained.
Okay.
So if she sustained it, you just stop, but, so was somebody watching, Ms. Reyes return to 224 Majestic Road?
Yes, sir. She started from there and she went back to the property. She was under surveillance the entire time.
And did she make any stops along the way?
No, sir.
Did she make any stops on the way back?
No, sir.
And did you tell us the location where the controlled buy went down?
Yeah, I don't actually have the numerics, but it's a CVS right across the street from the neighborhood.
About how far away is that from the house?
If I had to guess, maybe not even a quarter of a mile.
And did your CI make a plan to buy drugs from Ms. Reyes in the future, or?
Yes, he did.
Okay. And then what was your next action in this case?
So from there, we initiate the writing of the search warrant for the property. And that's what I worked on probably that afternoon throughout the evening.
So if you wrote the search warrant, wrote the affidavit for the search warrant on October 29th, 2022, is it your testimony that the controlled buy would have happened on the same day?
Yes, sir.
And so you're the affiant in the search warrant, is that right?
Yes, sir.
And can you walk us through, what do you do to you drafted that at the location, or do you go back to the magistrate's office?
No, in this case, I go back to our field office, which is out there in the area of Babcock and 410. Stay there probably the remainder of the afternoon until the evening. And then more likely, once I get approval from the supervision that the narcotic search warrant is good to go, then I will go get that signed downtown by one of the magistrates.
And then what's the next step once you get the search warrant signed?
Once I get the search warrant signed, I always like to run that search warrant within 48 hours. So I don't like to hang on that too long.
And so were you part of the team that served the search warrant?
Yes, sir.
Okay. Were you on the entry team?
No, in this case right here, I was assigned to the perimeter, which I believe I was just watching mainly the front of the house.
And did you take part in the search of the house?
Yes, I did, sir.
Okay. And what's the title for the person who collects the evidence?
So the title that we were using, we just call our evidence tech. I'm charged with not so much the discovery of evidence, but more of the recovery. Also the photographs.
Okay. So can you tell us the distinction there? You're not discovery versus recovery.
Discovery is more when you're on the search teams that you're actually finding evidence or locating.
And did you take photos as part of your duties that day?
Yes, sir, I did.
Can I approach the witness, Your Honor?
Yes.
You recognize, I'm sorry.
P1? Yeah. Yeah, but
I'm going to show you what I've marked as State's Exhibit P1. Do you recognize this?
Yes, sir.
Did you take this photograph?
Yes, sir.
Is that a fair and accurate depiction of the items you recovered from the house that day?
Yes, sir, it is.
Okay. Can you just generally describe what you see in the picture there?
Your Honor, may I take the witness on void time?
No.
Well, I think I want to establish that those pictures don't represent the location where the evidence was found.
Oh, well, they'll ask questions and I'll hear any objections that anybody has.
And again, Your Honor, we do re-urge the previous objections we've made to this evidence.
Okay.
Where did you take that photo?
This photo was taken in our Bear County property right before it was entered.
And so where did you recover these items?
From the property of Majestic Road.
And then I'm going to show you what's been marked. What I've marked is State's Exhibit P2. Did you take that photo?
Yes, sir, I did.
And what is that a photo of?
What I believe at that moment to be loaded syringes full of heroin.
I can mark this as State's Exhibit P3. Did you take that photo?
Yes, sir, I did.
Okay, and was that, where was that recovered?
That was recovered in the home in Majestic Grove, I believe. It looked like, I don't know if you would call it a living room or dining room.
And what did you, what is in that? Do you recognize anything in that photo?
Yes, sir, I do. I recognize a firearm, semi-auto pistol.
And can you identify what is State's Exhibit P4?
Again, firearm, import type assault rifles and one hunting rifle. And I see a semi-auto pistol that was also located in that same room.
And where did you take that photo?
In the house, Majestic Grove.
And do you recognize what I've marked as State's Exhibit P5?
Yes, sir, I do.
And what is that?
What I believe to be alleged narcotics, allegedly possibly methamphetamine.
And you took that photo?
Yes, sir, I did.
I'm going to show you what's been marked as State's Exhibit P6. And did you take that photo?
Yes, sir, I do.
And what is that photo of?
That is a copy of the narcotic search warrant, which was left in the residence.
And do you recognize State's Exhibit P7?
Yes, I do.
And did you take that photo?
Yes, again, I was trying to focus more on the warrant that was left at the residence per our policy. I just wanted to kind of show kind of a broader view of the warrant.
Okay. And what can you, do you recognize State's Exhibit P8?
Yes, I do. The defendant.
Okay. And did you take that photo?
Yes, sir, I did.
And are these fair and accurate representations of the items or person you saw that day?
Yes, sir. Yeah.
Your Honor, I offer State's Exhibit P1 through P8.
You said P1 through P8?
Yes, ma'am.
The same objections to we've made before, Your Honor.
All right, if I could see State's Exhibits P1 through P8, please. All right, defense's objections to P1 through P8 is overruled, and State's P1 and P8 will be admitted into evidence.
You mean through, sorry.
I'm sorry, P1 through P8, thank you.
So you took some photos and you were not discovering evidence, but you were, I guess, cataloging it. You were collecting the evidence.
Yes, sir.
Okay. And then what did you do next?
Typically when we're done, especially through the photos, that's one of the last things that I do is leave a copy of the search warrant. And then pretty much from there, I will go with all the evidence that was recovered and enter that into, transport that directly from the property straight to the Berry County property room and get all that stuff entered into the property room for further investigation and obviously testing.
And did you have an opportunity to speak to the defendant when as part of your duties out there?
Yes, sir, I did.
And did you, so how can you describe how that went to us? Did you read him his Miranda rights?
Yes, sir, I did.
Okay. And what did you say to him? What did he say to you?
Your Honor, we don't object to any statements by Mr. Myers. Allegedly, we think they violate Article 38.22 because they have not been electronically recorded as required. Additionally, there is no showing of compliance with Miranda v. Arizona or Article 38.22 as to the contents of the specific warning given or any kind of waiver.
All right, State, if you want to lay the foundation with regards to whether or not the Mr. Meyer was Mirandized.
Your Honor, the part of 38.22, it's section 3, subsection A. It says subsection A of this section shall not apply to any statement which contains assertions of facts or circumstances that are found to be true and which conduce to establish the guilt of the accused, such as the finding of secreted or stolen property or the instrument with which he states the offense was committed. And so the statement that I'm going to elicit from the witness is going to fit under this exception, Your Honor.
All right, but it hasn't been established that he was Mirandized. What does that mean? He's saying he Mirandized him, but what does that actually mean? What did he do?
Yes, ma'am. So Deputy Perez, can you describe the warning you gave to the defendant before he made the statement to you?
Yes, sir. So the whole reason for me talking to Mr. Meyer in the first place was because we couldn't locate narcotics. So I decided to take a crack at it. What I like to do personally for me is I like to Mirandize every time. The way I see it, there's no harm in not doing it. So I Mirandized them. I felt like I built a rapport with Mr. Meyer, talking to him while he was in the backseat of that Tahoe. I pretty much told him, we're not going anywhere until we find it. I said, work with me here. So I think I discussed, me and him had a discussion for about 5 minutes, where he finally makes a statement that, he puts his head down and he just says that she puts it in the vent. I didn't know what vent he was talking about, but I'm assuming it was one of the
Again, Your
vents.
Honor, I'm objecting, we're objecting to the foundations have not been laid for this statement.
All right, so just a moment. So because y'all are coming to me for punishment, technically, right now, where we are in the phase of this is it appears that we're having a motion to suppress as it relates to his statement. So in order for me to make a ruling on whether or not his statement was voluntarily given, I need to hear what the witness has to say on that. So your objection is noted. We're now moving into a motion to suppress phase. And if a jury were here, I would have the jury step outside the courtroom, but it's me that y'all are coming to. So right now, I'm hearing evidence as it relates to his statement and whether or not his statement is admissible. So in order for me to make that decision, I need to hear what the witness has to say on that. And then I'll make my ruling on whether or not it's admissible or not. And then you will have a chance to question the witness as it relates to that statement, Mr. Stevens.
I just didn't want to waive the objection.
No, I understand. All right, you may proceed.
So Deputy Perez, do you have the warning that you give, the Miranda warning? Do you have that memorized? Do you have a card? How do you do it?
No, I have it on my clipboard, and I always like to read off there. That way there's no misunderstanding. I like to read it verbatim as per I have it on the clipboard of the warning. I've always done that from beginning to finish. Is I go through the readings that way.
Okay. So you don't have it memorized?
No, sir, I do not.
Okay. But did you tell him that his statements would be used against him?
Objection to the leading question, Your Honor.
All right, that'll be, oh, I'm sorry, that'll be sustained.
What is the warning that you gave the defendant? What did you tell him?
It wasn't a Miranda warning.
And so what are the types of things that entails?
Well, I do remember just right off the top of my head, it's just, he does have the right, to stop at any point of the questioning, the proceedings. He understood that, if you couldn't afford an attorney, one way free of charge. So I kind of make it very clear that I kind of like to stress that he's aware that he can stop at any time that he wants. I asked Mr. Meyer if he understood his rights. He said yes, and then at which point I started questioning him.
So the warning that you give, that's on your clipboard, where did you get that language?
I got that language off what we have as our policy and procedure is through the narcotics office that we have filed. It's pretty standard.
Okay, so it's your belief that you complied with the requirements that you're supposed to require with per case law and policy.
Objection, that's the leading question, Your Honor.
All right, that'll be overruled.
Is it your understanding that you complied with the requirements of Miranda, that you followed the case law and departmental policy in giving the defendant the warnings that he's entitled to?
Same objection, Your Honor.
All right, that'll be overruled. You can answer.
Yes, sir.
Your Honor, I think I've laid the foundation.
All right, now the defense, you have a chance to cross-examine the witness.
Presently, Your Honor.
Yes.
Did you electronically record this conversation with Mr. Meyer?
No, I did not.
Why not?
I was under the assumption that it was. Usually, I can tell you why, sir, is, usually the deputies that we use out there are part of our gang and street crimes units. They are equipped with backseat camera footage, dash and body worn camera. So the only thing I can think of was a misinterpretation or some kind of failure of the system. But I did ask the deputy if there was a, hey, are we recording? I got an acknowledgement of yes, and I just assumed that everything was being reported. I usually do that because if he would have told me no, what my standard operating procedure is, I would have got another deputy or another investigator, like, hey, can you put this on your county cell phone that I reported that he was Mirandized?
Now, who was the deputy?
That I don't recall.
And what effort did you make? He told whoever the deputy was, you said you did that because it's your standard operating procedure. You know that's best practices to record things like this, don't you?
Yes, sir.
And you asked him and he said yes. It was recorded, right?
That was, I assumed.
But you don't know who the deputy is?
No, I do not.
Did you make a report about this conversation?
I wasn't aware.
I'm sorry?
I wasn't aware that it wasn't recorded.
Well, my question is, did you make a report about the statement you say you took from John Meyer on November 1st?
I believe so.
Where is it? May I approach you, Honor?
Yes.
Yeah, I don't see it in here, sir, but I'm just telling you what I did.
Well, I know you're telling us what you did, but you didn't make a report that says one word about taking an oral incriminating statement from John Meyer, did you?
No.
And you didn't record it, you said that. By the way, could we go over the reports you do have? I have a supplemental incident report. I see that in front of you. Is that the one you have?
Yes, sir.
Okay. I have a non-narcotic evidence report. You made that.
Yes, sir.
I have a narcotic evidence report. You made that.
Yes, sir.
Did you have anything to do with this sheet of paper that says involved property? Since you were the evidence technician.
Yes, sir.
Okay. And then, of course, the judge has your affidavit in support of the search warrant.
I'm assuming, sir.
Did you make any other writings in connection with this case?
Not that I'm aware of.
So what time did you, you said you were not on the entry team, correct?
That's correct, sir.
What time did you first speak to Mr. Meyer on November 1st?
I can tell you it was after Deputy G. Rios had spoken to him, and if I had, I would say probably maybe 10 or 15 minutes after Deputy George Rios spoke to him.
And he was in the back of somebody's car?
Yes, sir.
You don't know whose car it was?
That I can't tell you offhand. I don't recall.
How did you check to see whether or not this statement was recorded or not?
I didn't. I just assumed it was.
Well, you assumed it was, but we know it's not. So how did you determine it had not been recorded?
when we were being asked for it, there was video. So there, I was no longer part of our narcotics unit. I moved over to our general investigations division. And from there, I had said, I had asked deputies that were on scene to see if they can locate that video.
And you didn't.
No, they said they couldn't find it as well.
So do you know what time you gave the Miranda warning to, or the whatever warning you gave to John Meyer? Do you know what time that was?
Again, that was probably about 10 or 15 minutes after Deputy Rios spoke to him.
Well, what time was that?
I can't tell you off the top of my head. I don't know.
How long after the entry to the house was made did you speak to Mr. Meyer on November 1?
It could have been 45 to an hour.
So you don't know what happened with Mr. Meyer, who talked to him, or what was said to him before you talked to him when he was sitting in the squad car?
No, I do know that when Deputy Rios talked to him, that he didn't give him any information on where the narcotics were located. Not until I talked to him.
Well, I think my question was, do you know, well, what else do you know about, how do you know that? Did Rios tell you that? Or did you hear that?
No, he told me that.
Who told you that?
Deputy Rios.
Okay. Do you know anything else about whether anybody questioned him or?
As far as I know, it was just Deputy Rios. He was the primary case agent. I asked him if I could take a shot at it. I did. I Mirandized him. He told me where the narcotics were, and then they were located.
And you said it took you what, 5 minutes for him to make that statement?
Yeah, give or take.
And you said, we're not leaving, we're not going anywhere until we find it?
I told him, yeah, we were not going anywhere until we located that narcotics.
And up to that time, you said you had not located any narcotics in the house?
No, not any. There was some in plain view, but not what we were looking for.
And what specifically did you say that, but you didn't record, did you say that Mr. Meyer said to you?
Yeah, I talked to Mr. Meyer. I felt like we were making a report.
I asked you the question though, what did he say?
He said, yeah, she puts it in the vent.
Yeah, she puts it in the vent?
Yes, sir.
Who puts it in the vent?
I'm going to assume the co-defendant.
Don't assume.
Ms. Reyes.
Okay, you're assuming, you're guessing, or what?
No, I'm telling you, Ms. Reyes.
Did he use the name Miss Reyes?
No, he did not.
You assumed that. Is that right or not?
It's implied.
Implied, okay. And did you ask him who she is?
No, I did not.
And when did you first disclose, because you didn't make a recording of it, you didn't make a writing of a contemporaneous report of it. When did you first disclose that statement had been made, and to whom?
Immediately after when I was done talking to them, they were on scene.
Well, who'd you tell?
I told Deputy Rios and I told Deputy Wolf.
Is it in his report?
I couldn't tell you. I didn't read his report.
Did you know that Deputy Rios in his report says no admissions were made?
No, I did not aware.
Is that consistent with your testimony?
I'm telling you what he told me.
Who told you?
Mr. Meyer.
I'm asking you though, you said you told Rios.
Yes, sir.
Rios's report says no admissions were made.
I can't speak for Deputy Rios.
Did you tell anybody else contemporaneously?
I told Deputy Wolf.
Okay. Anybody else?
Not that I recall.
When did you first tell the district attorney about this statement?
I don't know, maybe a couple of weeks ago. Or
Couple
no,
of weeks ago?
You know what? Maybe about a month ago.
How about January 17th, 2024? That'd be right?
I'm possibly.
So at the time, you said that he made this statement. He was zip tied behind his back, wasn't he?
I don't know if he was zip tied or handcuffed.
Handcuffed, or is that, anyway, he was restrained physically.
Yes, sir.
Do you know when those restraints were put on him?
No, I do not.
Were you present when he was arrested?
I was there on site. I don't recall seeing him actually getting placed handcuffs on, but I don't know.
He was certainly under arrest at the time you spoke to him. He's in the back seat of a patrol car with his hands behind his back.
Which is why I Mirandized him.
Because he was under arrest at that time.
Well, he's got handcuffs on.
My question is, he was under arrest at that time? Yes or no?
I can't tell you. I'm not the case agent.
You said that's why I Mirandized him. Why did you Mirandize him?
I do that either way.
Why? When I asked you, was he under arrest? You said, that's why I Mirandized him. Is that your answer?
Doesn't necessarily mean you're under arrest just because you've been Mirandized.
But did you think you don't have an opinion about whether he's under arrest or not?
I think at this point, I didn't know I was entitled to any opinions.
Nobody's entitled to any opinions? So you didn't see when he was initially arrested, did you?
No, sir, I did not.
You didn't see when they put the handcuffs on him?
No, I did not.
You didn't see how many officers were surrounding him with loaded rifles?
There was quite a few.
Surrounding John Myers when they arrested him?
Well, given what was in the home,
They entered with rifles. They threw him on the ground and they put the zip tie
I don't know
on.
anything about that, sir.
You know anything about that? May I approach the video over here, John?
Yes.
Could you help me play this thing?
Yeah, sure. One of my playing.
It's on the desktop, I think. Can we approach? Yeah.
The state finishes with direct examination of this witness, we'll take up everyone else's cases. How long do you expect your direct examination?
5 or 10 more minutes, Judge?
All right, in defense, how long are you expecting cross?
Oh, I would think no more than 30 minutes, Your Honor.
Okay, all right, at least I thought it was gonna be an hour. All right, so this is what we'll do. Defense, do you have any more questions to this witness related to the admissibility of the defendant's alleged statements?
Could I consult and look at my
Yes.
notes?
And if they do not, Mr. McCray, do you have any witnesses?
I'm gonna proffer what the witnesses have to say.
All right.
We'll be very clear.
All right. Miss, you need to have a seat.
That's one thing I can think of.
All All right, any further questions?
Yes, Your Honor. So do you know, sir, if John Meyer, before you talked to him, invoked his right to counsel?
No, sir.
You don't know.
No, I do not.
Do you know whether he invoked his right to remain silent before you talked to him?
No, sir.
Well, in fact, no, that's all I have.
All
No,
right.
no more questions on the motion.
All right, no more questions on the motion. All right, I'll give both parties a chance to formulate your arguments as to whether or not that's admissible. And while you all are doing that, we will take a break and we'll take up Mr. McCrae's client. Are you ready? All right. Sorry, we're switching records on records.
I'm thinking.
All right. All right, court is going to call 2024 CR 2118, 2024 CR 2119, and 2020 CR 5287. And there's one more. All right, let me call it again. It's 2024 CR 2118, 2024 CR 2119, 2024 CR 0459, and 2020 CR 5287. State of Texas versus Misael Solis. Could I have parties announced for the record for the state?
Jason here.
Defense.
Good morning, Your Honor. I'm Todd Spray for Misael Solis.
And are you Mr. Solis? All right, we're here for sentencing. The defendant entered a plea to count 2 and the cause number ending in 2118. According to that plea bargain agreement, punishment is to be assessed at a cap of 12 years. The state is opposing your application. There are certain items that are being taken in consideration and all cases are running concurrently. And the case number ending in 2119, the defendant entered a plea in count 2. And according to the plea bargain agreement, punishment is to be assessed at a cap of 12 years. And in 2024, CR 0459, according to your plea bargain agreement, punishment is to be assessed at a cap of 10 years. And in cause number 2020 CR 5287, the defendant entered pleas of true to a violation of conditions 1, 2, and 5. The court found those allegations true. And according to the sentencing in that case, there is no agreement, but the court could sentence you up to 3 years in prison. Have both parties had a chance to review the PSI report state?
Yes, Your Honor.
Defense?
Yes, Your Honor. I reviewed that with Mr. Solis.
All right, any objections?
No, Your Honor. Nothing to say. I have one minor, it looks like a clerical objection, Your Honor.
Yes.
If you sorry, I'm looking at the tab. Page 8 under the narrative,
Yes.
Mr. Solis is not an African American male.
I was wondering that because of what it said based upon who they said his parents were.
Correct.
But hey, all right. Yes.
Your Honor, just by way of background, so we were here in January 8th, 2024 on the MTR. And that's when Misael entered a plea of true to one of the violations of the conditions alleged. And we noted to the court on the 18th of January that according to probation's recommendation, probation was recommending to extend 1 year and then conditions to include state ISF, substance abuse track, followed by ISP supervision and a cognitive behavioral course. And Mr. Solis spoke to you directly, and I spoke to you on his behalf. And we were asking the court to do that. And Mr. Solis requested help and treatment And the court wanted to know at that time, before the court made a decision on the probation violation, about these other new number ones that were listed in the NPR. What the state told the court is that they weren't ready to proceed on those because they were waiting on lab reports and they were waiting on indictments. And so we were unable to resolve those other pending new number one cases that were on the court's docket. So what the court did is extended the hearing, and we did that several times between January and today. And eventually what happened is the state was able to get the lab reports, the state was able to get indictments returned. And it was the last court date, which I believe April. What we did is we offered the court a plea bargain agreement on the new case.
Yes.
So that's what the court described in the court called the case a few minutes ago. At that time, what the court said is, what we're going to do is we're going to send this to the probation department to decide and a TAP evaluation, which the court has noted. And so I will again note for the court that probation again is recommending what I just said. The state ISF program, a TAP evaluation has been done, and there's actually another alternative in there, a less restrictive residential patient accommodation. On his behalf, I wanted to note for the court, and I'll just proffer this evidence. He has his brother Emmanuel in the court. Will you stand up, Emmanuel? He has his mother Martha in the court. Will you stand up now? Yes. He has three family friends, one of whom is a potential employer and a former employer. Louis, will you stand up? Sylvia, will you stand up? Yes, sir. Thank you. So, Judge, in talking to Mr. Solis about what he wanted the court to hear at his sentencing, I asked him.
You can be seated. Thank you so much for coming down.
I asked him that the court would want to see what kind of family support he has. The court is going to consider the residential program, which he's asking you for. He asked you for that at the January hearing, and he asked you for that at the April hearing. He gave you some of his background, although it was limited. But I wanted you to see that he has really great family support, stepped up. He's coming to his brother Emmanuel, is a law-abiding citizen. He is in support of his brother being on the right track. His mother is very supportive. She loves her son, and she wants her son to have the treatment and the help that he needs. And his employer, Louis, is here. That would be his boss. He's formally employed ECIL and is here to tell the court that he has employment waiting at the point where that would be appropriate. I think in the PSI, ECIL, in his statements to the probation, has been very intelligent, very honest, and admitting to what his problems are. The CAP evaluation is very accurate. You can see there's an extensive drug use history. A little bit about how he got here, Judge. He was, as you know, he was in prison for a period of time. He was released on parole, and then pretty shortly thereafter, he was arrested for the offenses that are before the court and the probation violation. He tells me he was not ready to re-enter the community. He fell back into the same patterns that he had, and he's according to the PSI, they're saying that he's in the contemptible phase, and I think he has made contemptibly the right, knows the right course of action, and so now it's the next step of actually doing those things. I think he's ready to do those things. He's concerned about his father's health. He's concerned about his daughter, his 12-year-old daughter. He's 31 years old and he's ready for a change in his life. And what he's done is, I felt this was exemplary as well, Your Honor. He didn't want to stumble with his words, and I know you're going to want to talk to him. A short letter to the court, I think.
Any objections to the court reviewing the letter?
No objection. It tells you where he is in his feelings and his thoughts about this hearing.
All right.
So, and I'll let me CIL address the court, and ask the court, what he'd like the court to do and why.
All right, if you can raise your right hand for me, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, what would you like to say?
Ms. Boyd, I just want to ask for help. I don't feel like going back to prison is going to change me. I spent the past 8 years in prison and missed out on a big chunk of my little girl's life. And right now she's 12, going on 13. I feel like right now it's the time that she really, really needs me there. You know, and I know she needs me as a child, but right now she really needs that guidance and support.
All right, so I can tell you right now, this is what I don't understand. In this court, anybody who has an issue, I always tell them, if there's an issue, talk to probation. If you feel as though probation is not addressing it, you can always come to court. I will tell you right now, it is rare if anybody thinks prison is the place for them. Even people who are charged with murder, many times they don't think, they're like, prison is not the place for me. I'm not going to learn anything for prison. But sometimes that's where we are. So I want you to explain to me, if you had a drug or alcohol issue going on in your world, why didn't you talk to probation before all of this happened? Or why didn't you come back to the court? Because we're always here. I always tell everybody we're here throughout the week, except on holidays and weekends.
When I was on probation, I was still in Houston. I was at a halfway house in Houston. And I was working, I had a job, but when I got kicked out of the halfway house, I got sentenced back to San Antonio. And coming back to San Antonio, I don't feel like it's good for me. It's I feel like it's better for me to be away from here, you know, because like I told you, my lawyer, we fall back to same things, the people, places, and things. And I feel like that's detrimental to me, you know, right there, the people, places, and things.
Let me see something here.
What's going to stop you from court did this? Got you the help you need. What's going to stop you from going back to these people, places, and things?
I know this is the last road. This is the last chance. This is it. No, there's not gonna be anything else after this. And I want to be successful. I want to help the people out. It's been helping me this whole time.
And see, here's the thing I want you to understand. When I place people on probation, I want them to be successful. And I was looking back at this case that you're on probation for. The state recommended probation. And honestly, even though looking at your history, I see your history is littered with drug cases, right? Some with intent to deliver, some with possession. So I do understand that you probably have a drug problem. But with regards to the state recommending you to have probation on that evading case, I could have said, no, I'm not accepting this. I don't think it's appropriate. But I took a chance. And the reason why I took a chance is because I believe everybody's a human being. If I think it's appropriate for someone to have probation and at the same time protect the community, I'll do it. I want people to be successful. I want you to be in your daughter's life. But you've made some choices that are not good choices. The choices you made in each of these cases, and I always reread everything. You made a choice with these drugs, right? You made a choice to evade. You didn't pull over. There's so much going on. You've been to prison before. And now you come to me and you say, I'm ready to change. So what I can tell you is I don't think probation is appropriate for you. I understand probation's recommendation. Probation?
Yes, Judge. I ask him one thing, Judge.
Sure, I just want to see what your recommendation is as it states. And when I say your recommendation, I mean the person who interviewed them, their recommendation is what it is. Is that correct?
That is. One second, Judge.
And I believe their recommendation is saying that if the court were to grant your application, then they're asking for these different types of treatments potentially.
That is correct. If the court
Grants.
grants.
All right, and you wanted to ask another question, counsel?
Right, Judge. DCL, have you ever had, and I reviewed with you the TAP evaluation, which is again in alignment with him needing extensive treatment,
Mhm.
recommending what the court sees. I've described the two alternatives, which are residential treatment for DCL. Have you ever had residential treatment for substance abuse? As in, you're gonna be residential, you're gonna be on probation, residential treatment for drug abuse.
I have been on probation for years.
Right, but have you received residential treatment? No. Okay, you've never been in a residential treatment program. And the court noted and has noted that your history is quite extensive with substance abuse, but you've never had residential treatment for that substance abuse. Is that correct?
Yes.
And are you motivated? Judge Boyd is looking at his record very carefully. Are you motivated to do the residential and to show her? And you know, she could, if you didn't do that residential, she could bring you back, send you over and send you upriver, so to speak, and you could be looking at more time than what's in your plea agreement. Yes, I'm ready.
All right. And state you're opposed?
Yes.
All right. Mr. Solis, I want you to know that I internalize everything that everyone says. I believe everybody is a human being. And sometimes people will ask me, well, how can you do that? And it's because whenever I see people before me, I'm always wondering what happened in a point in their life where they went left and they should have went right, or they went right and they should have went left. So I see everybody as individuals, and I never make up my mind about a case and what I'm going to do with the case until I hear the individual before me. All right, so what I'm going to do, I'm going to deny your applications. And cause number 2020 CR 5287, the court is going to sentence you to 3 years in the prison, give you credit for any time served. This will run concurrent with 2024 CR 0459 and 2024 CR 2119 and 2024 CR 2118. I'll recommend the therapeutic community for you. I have no authority to force them to place you in the program, but I know if you don't ask for it, they won't place you. And in cause number 2024 CR 2119, I'm going to sentence you to 8 years in the prison, give you credit for any time served. This will run concurrent with 2024 CR 2118, 2024 CR 0459, 2020 CR 5287. Take in consideration 2024 CR 2120, 2024 CR 2121, 2024 CR 0459, and I'll suggest the therapeutic community. They're saying there's a laboratory cost for drug testing of $790. Any objections to the court including that?
He's indigent, so we'd like the court to take that into consideration, and I am appointed.
All right, there's to be restitution of $790 to the Bexar County Laboratory for testing. And in cause number 2024 CR 0459, court is going to sentence you to 8 years in the prison, give you credit for any time served, run concurrent with 2020 CR 5287, 2024 CR 2118, 2024 CR 2119, take in consideration 2024 CR 2121, 2024 CR 2120, 2024 CR 0458, and I'll recommend the therapeutic community. And 2024 CR 2118, court is going to sentence you to 8 years in the prison, give you credit for any time served. This will run concurrent with 2024 CR 2119, 2020 CR 5287, take in consideration 2024 CR 0458, 2024 CR 2121, 2024 CR 2120, and I'll request the therapeutic community. In each of the cause numbers, did you review the trial court certification with of defendant's rights to appeal with your counsel? Did you understand it and did you sign it?
Yes.
In each of these cause numbers, because there was a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. I know you have a young daughter, and by the time you're released, your daughter is probably going to be heavily into her teenage years. Once you're released from prison, you can't go to the home and act as though you're in charge and you're the father. You understand? Because you've been away. Now, when you're released from prison, if you have trouble finding a place that can help you with drug treatment, as they say, God willing and the creek don't rise. If I'm here, you can always come back here and I will find a treatment place for you. You understand?
Yes, ma'am. Thank you.
All right, good luck to you. And you should be appreciative that your family came, okay? You're welcome.
Thank you, Judge.
All right. On Louis Thompson Fletcher. Norma, can we recall this, please? Since Louis Thompson Fletcher, defense counsel, is in trial.
Yes, ma'am. You said on Thursday.
All right, so we'll bring it back on the 18th. Christian, I'm sorry, Cherish Japer Ward. Come forward. Where is she?
She's in the box.
All right, Ms. Ward, if you'll come forward.
I believe the name is.
Oh, it says Cherish on here. So, all right, so we'll have to make sure that that is corrected. All right, medical issues. That's what we were here for last time. There was some kind of medical.
Oh, I had my wife in dental surgery.
Oh, yes.
And
Okay.
they would not do it without me.
Oh, how's she doing?
She's doing better.
Oh, that's good. All right, so what's going on with this case?
We have conferred, Judge, just the first setting we are working towards. Either an offer or a resolution.
All right. So has an offer been tendered?
No, Judge, but I think defense, they were gonna be one some case law that they wanted me to look at when considering this case.
All right, Norm, if you can set this for the second week in May, please.
Yes, ma'am. 1 second, Judge.
And I don't know what's going on, but if you're using your sister's information, you need to stop, because that makes it very difficult when somebody else is out here allegedly committing crimes and using your name. It takes money for somebody to correct that. And then if they end up getting pulled over because you have a warrant and you use their name, that's an issue. I've represented plenty of clients before, and they would have to carry around a piece of paper with them because they would keep getting pulled over. And it would have to be a document from the sheriff saying, this is not that person. All right, what date?
May 14th.
All right, we're going to come back on May 14th. Victoria Velez.
Your Honor. We're ready. Good morning, Your Honor.
Good morning. Hello.
I think this is the first setting. We're just.
All right, she needs to come up. Hi, no problem. Take your time.
Sorry.
All right, why were you late for court?
I told my attorney, I had an appointment with my oncologist and I thought it was gonna be okay, but it ran a little extra, so.
Oh, no problem. Just let us know next time, okay? All right, so,
Judge, we're conferring, I believe this is first setting, second setting, there's some health issues that you're gonna find. She has far more things planned. She said in 3 weeks.
Yeah, we're gonna be discussing it because I have AML.
She had leukemia.
all right, when is that taking place?
When is that? Just a discussion or?
Yeah, we're discussing it in 3 weeks, so.
3 weeks.
All right, so when is that taking place?
In 3 weeks, we're gonna discuss it. Gosh, I think, May the 11th.
All right, Norma, recall this for May 30th, please.
Yes, ma'am.
Your Honor, if possible, June 4th, I'm gonna be doing graduations on the 30th, the last couple days.
Okay.
Apologize.
Oh, no problem. I realize you're a teacher. All right, Norma, June 4th.
Yes, ma'am.
Thank you, Judge.
All right, you're welcome.
And I'll get you a preset.
Okay, thank you, yes.
Devin's actually graduating, Judge, too.
Oh, my gosh. I remember when they were little babies.
Bates.
Now they're living their lives.
Keep talking.
All right, have a good one. Larietta Holmes. Who's the attorney for Larietta Holmes? Yes.
Judge, good to see you again.
Yeah, yeah, it's like I hadn't seen you before. All right. So this one, we can recall it on June 4th as well?
Absolutely.
All right, and you all will need to confer off docket.
Yes, ma'am. Yes, ma'am.
All right, is there anything else?
No, ma'am.
All right, thank you so much.
I'm gonna wait. Then Judge, I have one more case, in Gilbert Perryman. I'll wait for that one.
All right, Gilbert Perriman.
He was here.
He's been here.
Okay. He is here.
All right, what's happening with this case?
Your Honor, this is another one just, was recently indicted, so June 4th.
All right, come back on June 4th, and I expect to see some movement.
Yes, Your Honor.
All right, thank you.
Thank you, Judge.
Once you sign the reset form, you excuse.
No promises.
Sarah Gutierrez.
Sorry.
All right, and has she been accepted?
So, Your Honor, she potentially is not going to there's a potential employment from the fire department. So we're moving into a different phase of our negotiations at this point. Trying to work out the two cases she has, this case and the case in county for violation of protective order.
All right, so when is this going to be done?
Judge, there was one other thing.
Sure, if y'all will step back.
Sure, thank you.
April Ann Pettis.
Sure.
April Ann Pettis.
Sorry, Judge, is that? Give me 1 second.
During the branch.
Oh, that's the bond publication.
It is? Okay, we'll take that up in a minute.
Okay.
Excuse me. Hi. You can go ahead and take your break.
For lunch, you mean?
Yes, and we'll be back at 1:30. All right, everyone, we're going to be back at 1:30. So this is what's going to end up happening. Everyone who has your please be here at 1:15. And we will take your pleas up. Yes. Okay, whenever you're here, we'll take it up at a break.
Yes, and he's in custody, so.
And Eric Campbell.
Okay.
As soon as I finish my job.
All right, thank you.
So we can't do anything now.
Yeah, no, I.
I just was asking for a